leisure. Then we're going to discuss more in depth some of the defenses and some of the more interesting areas that are coming up still, because there are still reported cases on preferences with defenses. And then time permitting, but just to give you a preview, at the back of the deck, starting on page 43, we talk about some practical advice and some strategies in dealing with preferences. And so with that, I'm going to turn it over to Robin to kick it off.
Good afternoon, everyone. Again, this is Robin Rahman. I'm a bankruptcy attorney with Kilpatrick Townsend. I'm in the Atlanta office, and thanks very much for taking time out of your day to join us. So I've been practicing about 15 years, and I've certainly encountered my fair share of preference complaints, both as a plaintiff and a defendant. And what I've seen over my years is that the most common outcome of a preference action is simply a settlement. Actual litigation, whether it be full-blown discovery, trial, motion practice, is more limited, and an actual published decision delving into these issues is even more uncommon. And then binding precedent from an appellate court is more rare still. Nonetheless, there's a body of law that has developed around the statute over the years and continues to develop. And so today we're going to hit some of the highlights and hopefully make you a bit more prepared if and when you face your next preference complaint. So we're going to hopefully address 4 things over the course of the next hour. What is a preference? What are the statutory elements? What are the statutory defenses? And then the strategies, as David mentioned a moment ago. So just diving right in, the first question, what is a preference? And I think this statement from the Freedman's case provides a succinct definition of what a preference is. In its simplest terms, is an eve of bankruptcy transfer to a creditor. The creditor that receives a preferential payment recovers 100% of its claim, where in all likelihood, other unsecured creditors receive less. So in general sense, it's a debtor preferring one creditor over others. And while outside of bankruptcy, that's probably fine in most instances, once you reach that zone of insolvency or become a troubled company, it becomes subject to preference attack. So the actual statute is set forth in 11 U.S.C. Section 547B and also Section 550, and that's generally referred to as the Bankruptcy Code. And an important aspect of this is that the preferences are simply voidable, but they're not void by themselves. So something has to happen for them to be unwound. In general, the statute gives a bankruptcy trustee the power to bring a preference claim. However, under another section of the Bankruptcy Code, Section 1107, debtors in possession are granted most of the powers of the trustee, including the right to sue to recover preferences. You may also see under, for example, a plan of reorganization or a liquidation or some other court order, other parties who were granted the right to undertake a preference action, such as a creditors committee, a liquidating trustee or a plan administrator, or something like that. So the purpose of the preference statute is twofold. Discourages creditors from racing to the courthouse to dismember the debtor as they slide into insolvency or into bankruptcy. And then it also facilitates the prime bankruptcy policy of equality of distribution among creditors to the debtor. And again, the statute itself makes clear that intent of the parties is completely irrelevant, unlike certain other statutes, like, for example, a state law fraudulent conveyance or a fraudulent transfer statute. So really, if the trustee is successful in showing that the elements of a preference exist, it's irrelevant whether the parties intended for it to be that way. It simply is. So here are the statutory elements. There are 5 basic things that you must show, that the trustee must show in order to avoid the transaction. And the preamble is important as well. It says the trustee may avoid any transfer of an interest of the debtor in property, 1, to or for the benefit of the creditor, 2, for on account of an antecedent debt owed by the debtor before such transfer was made, 3, made while the debtor is insolvent, 4, made within 90 days or within 1 year if you're an insider, and then 5, that enables such creditor to receive more than such creditor would receive in a Chapter 7 liquidation. So those are the 5 basic elements. So the first question is, okay, well, what is a transfer? Well, transfer is defined, it's very comprehensive, includes every conceivable type of conveyance of an interest in property. Section 101.54 makes clear that it includes both direct and indirect transfers, voluntary, involuntary involuntary transfers, and any other effort to dispose with property or an interest of property. Now, the vast majority of time, the transfer addressed in a preference context is really nothing more than a payment of money, but the definition is much broader, and so it can constitute any sort of change in ownership or possession, such as a loan of property, for example. A physical transfer is not necessarily required as long as the transferee obtains legal rights to the property itself. The granting of security interest or other lien constitutes a transfer, and as I mentioned before, it can be voluntary or involuntary. The next element, interest of the debtor in property. So the Bankruptcy Code doesn't really define this, as you'll see is sort of a recurring theme in the statute. Luckily, the Supreme Court has defined this as property that would have been part of the estate had it not been transferred before the commencement of the bankruptcy proceedings. And really, the fundamental inquiry is whether the transfer diminished or depleted the debtor's assets. And oftentimes, what you'll do is look to state law to figure out whether the asset would have been part of the estate and whether the transfer diminished. To or for the benefit of a creditor. So Section 101.10 defines a creditor very broadly to include an entity that has a claim against the debtor that arose at the time of or before the order for relief concerning the debtor. So virtually any type of creditor. Any creditor with a claim against the debtor is going to be considered a creditor for purposes of the preference statute. On account of an antecedent debt. The term antecedent debt is, as you'll see, as I've said before, is a common theme. It's not defined by the code. The common sense definition applies here. A debt is antecedent if it was incurred before the transfer or payment from the debtor, and in general refers to the time when the debtor first became legally bound to pay. So here's some examples. So for goods, it really depends on the party's contract terms, but the debt is incurred on the delivery date or on the shipment date. For services, on the other hand, the debt is incurred on the date the services are rendered. Now, in contrast, a prepayment cannot be avoided because they are not made on account of antecedent debt. There was no debt owed at the time of the payment. So as straightforward as it may appear, antecedent debt can get a little bit problematic when the debt and payment are nearly contemporaneous. So generally, a contemporaneous exchange of equal value will not be considered an antecedent debt. But take, for example, a secured financing creditor, such as an equipment financer, who intends for a nearly, take, for example, secured financing creditor, such as an equipment financer who intends a contemporaneous transaction. If the financing creditor does not perfect immediately or within the statutory grace period, then the transfer may be deemed for or on account of an antecedent debt owed by the debtor before the transfer was made. And that's under Section 547E. Therefore, we always advise our secured creditors to immediately perfect their security interest so that this potential problem is averted. Made while the debtor is insolvent. The statute looks to a balance sheet test. A debtor is considered insolvent when its debts are greater than its assets at fair valuation, and that's exclusive of property exempted or fraudulently transferred. And fair valuation is further defined, or at least recognized by most courts, to mean fair market value of the debtor's assets and liabilities at the time of the alleged preferential transfer. Now, when showing insolvency, the trustee's case is made stronger by Section 547F, which provides for a rebuttable presumption of insolvency during the 90 days immediately preceding the date of the filing of the petition. So while the trustee must still establish the other elements of the preference, Section 547 shifts the burden to the creditor to come forward with evidence to rebut the insolvency presumption. The insolvency presumption in the code makes the trustee's job a good bit easier than the creditor's. Because of this, trustees usually just sort of ignore the insolvency, and but the creditors might have information that has been filed on the docket that can help them in their case. So, for example, if the debtor has filed schedules of assets and liabilities, what you might find in there is a schedule that makes clear that the assets were worth more than the liabilities at the time of the filing, in which case you would have sworn testimony that they do not satisfy the balance sheet test, and we're not insolvent. Now, this doesn't buy you that much because you're just going to have to go on and actually have a contested hearing on the issue of insolvency. But nonetheless, there are ways that you can overcome this rebuttable presumption. The reachback period. Determining the scope of the preference period is simply, a matter of counting back 90 days from the bankruptcy petition date. And this also holds true in voluntary bankruptcy cases where a creditor will, or a group of creditors will file a petition to have the debtor placed into bankruptcy. With respect to insider preferences, the rule is a little bit different, and it goes back a full year. Insiders under Section 101.31 of the Bankruptcy Code include, but aren't necessarily limited to, relatives, general partners, directors, officers, persons in control, managing agents, and affiliates of the debtor. So if the transfer was made to an insider within 1 year, the trustee can avoid the transaction, just as it could for a transfer made to a non-insider within 90 days. One important note about insider transactions, however, the presumption of insolvency does not apply from the 90 days to the 1 year, so that's an extra wrinkle. The final element of the preference statute is that it has to result in a greater distribution than the hypothetical Chapter 7 distribution. And the real purpose here is, if the creditor doesn't need to return a sum received from the debtor prior to bankruptcy if the creditor is no better off with respect to the other creditors of the bankruptcy estate than he would have been had the creditor simply waited for the liquidation and the distribution of assets of the debtor. The trustee has to figure out the creditor's appropriate class and then assess the distribution that the class would have received if the transfer had not been made. In most cases, if the bankruptcy case provides for less than a 100% payout or 100 cents on the dollar, then a preference likely exists. Now, there are certain types of claims that are likely to get paid even where there's not a 100% payout. Examples of those would be, for example, creditors that are fully secured by the collateral, so the value of the collateral exceeds the amount of the claims, they're fully secured, and it really is irrelevant what happens in the Chapter 7 case. They're going to get paid in full, so they would not have received more in a Chapter 7, receive a greater distribution than a hypothetical Chapter 7 distribution. Similarly, priority creditors, or creditors with valid reclamation claims, or other creditors who have executory contracts or unexpired leases that were assumed during the pendency of the case. Probably not an issue in a Chapter 7 case, though it could be, but in any event, these are all examples of creditors who, despite the fact that there wasn't a 100% payout, still would not be considered subject to a preference action because they were made no better off either way. So those are the basic elements of a preference statute. There's a couple of other ancillary issues to consider, the first of which is who can be liable for a preference transfer. And Section 550A sort of highlights those entities. There's the initial transferee, the entity for whose benefit such transfer was made, and then any immediate or immediate transferee of the initial transferee. So a couple of examples that might help explain these a little bit. So a third-party guarantor of the debtor whose liability is reduced by the debtor's payment of guaranteed debt. I think that would be a good example of an entity for whose benefit such transfer was made. A third party whose debt is paid by the debtor, with payment going to the third party's creditor as the initial transferee. Or, for example, an undersecured junior creditor who is benefited by the debtor's payment of the debt that was secured by a senior lien. Section 502D presents another consideration as well. Under 502D, a court disallows any claim of an entity from which property is recoverable under Section 550 unless such entity or transferee has paid the amount or turned over any such property. In a nutshell, if you are owed an amount from the debtor, but you are also subject to preference liability, 502D says that the amount that is owed by the debtor to you must be disallowed until you disgorge that amount. And that can be problematic. Take, for example, a situation where a creditor's claim is $1 million and the preferential payment was only $100. Well, the entire creditor's claim is going to be disallowed unless and until the creditor repays the preferential payment to the debtor's estate.
And just to add, while Robin's changing the slide, the corollary to that is there are a couple of cases that have come up that have said that if you settle the amount of your claim before the preference is resolved, there's a couple of cases that say you might be able to use the 502D settlement as a preference defense.
So what we just talked about were the basic elements of establishing the existence of a preferential transfer. And, if you read enough of these cases, what you realize is that, in 8 out of 10 cases, the trustee and the defendant will stipulate to the existence of a preference, unless there's some other factual reason why the preference doesn't exist. But you'll see in a lot of cases there's stipulation over the existence of the various elements, and what you're really discussing at that point then is the defendant's ability to rely on one of the common defenses to negate the preference liability. And there's really only 3. Well, there are more than 3, but the 3 most common defenses that you see asserted are set forth in Section 547C1, the contemporaneous exchange defense, Section 547C2, the ordinary course of business defense, and Section 547C4, the subsequent new value defense. And, by and large, it seems that the ordinary course of business defense, which we'll discuss after contemporaneous exchange, has garnered the most litigation and the most comment by bankruptcy courts and appellate courts. So let's talk about the first one, 547C1, contemporaneous exchange. So this is the defense that applies when there is a, quote, contemporaneous exchange for new value provided to the debtor. And the purpose is a common purpose throughout all these defenses, but it's to encourage creditors to continue to deal with troubled debtors without fear that they will have to disgorge payments received for value given. And then also because other creditors are not adversely affected if the debtor's estate receives new value. And you'll see these themes reoccurring throughout the defenses. Now, under this section of the Bankruptcy Code, a preference cannot be avoided by the trustee if you can prove 3 things. The first, that the transfer was intended by both parties to be contemporaneous exchange. Second, the exchange was, in fact, contemporaneous. And 3, you gave new value to the debtor. So intent is quite key in this particular defense. And courts have held that transactions that appear on their face to be a contemporaneous exchange for new value may still not be considered as such if there is evidence that the parties did not intend the exchange to be contemporaneous. And this can be difficult, it can be a challenge to prove if you have, for example, an uncooperative debtor, or more likely, if you have a trustee who is simply inherited the books and records of the debtor and has no basis to provide you with discovery that would support your case that they also intended it to be a contemporaneous exchange. But the conduct of the parties and any writings and communications between them can be used to establish intent. So keeping good records of your own is key. Okay, so notwithstanding the intent of the parties, the defense further requires that the exchange was in fact contemporaneous. So there is flexibility in the statute for what is meant by contemporaneous, but it's highly fact specific. So for example, checks can be contemporaneous even though they don't necessarily clear on the day that you provide them, but then it can become complicated if the check, for example, is later dishonored. So take the example on the slide. A seller shipped goods to a buyer on credit and subsequently received the buyer's check for a full amount owing. The check was then dishonored. Based on the buyer's assurances that the check would be repaid in full, the seller shipped additional goods to the debtor. The previously dishonored check was paid upon redeposit, but the seller was never paid for the final shipment. The payment is avoidable because the parties intended the check to be payment for pre-existing debt rather than a contemporaneous exchange of new value. So that's a sort of a real-world scenario that likely happens every day. One check is either dishonored or it's for an inappropriate amount. For some reason, it gets reversed, and then it gets paid later. You can see how this contemporaneous requirement can become problematic for this defense. Now, the other requirement is that you have to have given new value, and you have to prove a specific measure of new value was provided to the debtor. It must generally actually enhance the worth of the debtor's estate, And so, for example, if you are simply forbearing from levying on a judgment or something similar, that doesn't really constitute new value. That's just forbearing on rights. And the defense really only protects preference transfers to the extent that the creditor can prove that the value given to the creditor equals, the value given to the debtor equals the value the debtor received. So the next defense, and I think this is probably the one that most people are familiar with or have had some experience with, and it's certainly one that's garnered the most litigation and discussion. This is in Section 547C2, the ordinary course of business defense.
Yeah, and I'll just add, as before Robin talks about the defense, that unlike new value, which we'll talk about after ordinary course, which I like to describe as can be a knockout punch, in the sense you do the analysis and you either gave new value or not, and it reduces your preference exposure. This one, and that's why Robin will spend a fair amount of time on it, is really a litigation defense, and it has a fair amount of nuance, and there's a fair amount of relatively new case law, maybe not a fair amount, but a few new cases that have helped inform this one.
So the purpose of the ordinary course defense is fairly similar to what we saw with the contemporaneous exchange defense. It's intended to basically protect recurring customary credit transactions that are paid for in the ordinary course of business of the debtor. And you're really trying to promote or to induce creditors to continue dealing with the debtor and to continue extending ordinary trade terms even as they slide into insolvency. And I found this good quote that I've seen a number of times, and I think it really, it's I guess how bankruptcy judges write. It basically says, the purpose is to induce creditors to continue dealing with a distressed debtor so as to, quote, kindle its chances of survival without a costly detour through or a humbling ending in the sticky web of bankruptcy. So a rather dramatic way of describing the purpose of the statute. But nonetheless, that's what it does. So you have to prove three things. The first, and the least worthy discussion, is the underlying debt on which payment was made was incurred by the debtor in the ordinary course of business of both parties. The second thing is you have to, the next part is an either or. It's either A, the transfer was made in the ordinary course of business or financial affairs of the debtor and the creditor, the so-called subjective test or prong. Or you have to prove that the transfer was made according to ordinary business terms, and this is the so-called objective or industry test or prong. So let's look at each three of these individually. The first is the debt was incurred in the ordinary course of business of the parties. As I mentioned before, this is the least important of the three different standards. But basically what it means is that the creditor must show that the debt, which was paid during the preference period, was a debt which was incurred in the ordinary course of business or financial affairs between the parties. This element really isn't contested by the trustee that much, and a creditor can easily prove this element by establishing that the debt paid related to the way that the debtor and the creditor ordinarily did business themselves. So courts will assume that the requirement is met by inferring from the evidence that there was nothing unusual about the transaction. Occasionally you'll see a situation where a debtor who is new to an industry or is venturing outside of its own business will not be able to meet this problem because it's never done business before, so it was not incurred in the ordinary course of its business. But that's a rare situation, and as I mentioned before, in most circumstances, that people sort of just gloss over this requirement, but it does exist. So the next thing that the second and the third elements of the ordinary course defense have received, I think, the most attention by courts, and these are known as, I mentioned, the subjective test or the objective test. It's important to note that these two tests were put into effect, there were changes put into effect in the Bankruptcy Code in October of 2005, and now you only have to establish either the subjective test or the objective test, whereas before, pre-2005, you actually had to prove both of them, which was a fairly high standard. So there's been a significant relaxing of the standards since 2005. So as to the first one, the subjective test, this refers to the course of dealing specific to the debtor and the creditor, so the course of dealing amongst the parties. In conducting the analysis, courts compare the relationship between the parties before the preference period and then the conduct of the parties during the preference period. If, for example, the creditor is to coercive collection efforts inside the preference period to force payment, then such circumstances may generally take the relationship outside the ordinary course of the normal dealings. However, if, for example, these coercive payment collection efforts had been sort of ordinary operating procedures amongst the parties, then a compelling case could be made that that was ordinary course. Now, frustratingly, payment terms, contract terms, whatever's in your agreement are largely irrelevant for this test. It really doesn't matter what the parties have written down in a contract or in an invoice or any other sort of written or oral agreement. That's largely ignored in connection with the subjective test. It can be relevant, but for the most part it isn't. What's most relevant is the course of conduct. And the hallmark of the payment in the ordinary course is consistency with prior practice. Now, courts, when considering the ordinariness of transfers, I'm not sure if that's a word, but I'm going to use it as a word today, will consider a list of factors. You know, the timing of the transaction or payment, the length of time the parties engaged in the type of dealing at issue, whether the transfer was an amount more than usually paid, so if they're, you know, paying a consistent amount for a long time and then right before the bankruptcy case they start submitting huge payments, that's relevant. Whether payments were tendered in a manner different from previous payments, so if they, you know, changed from check to wire, from wire to check, or paying multiple invoices at once, so-called batching. Whether there was any unusual action by either the debtor or creditor to collect or pay on the debt, so, you know, requiring the debtor to pay past invoices before shipping new goods. Whether the debtor did anything to gain an advantage in light of the debtor's deteriorating financial condition. So this could be, you know, threatening lawsuits or, refusing to ship additional goods until payment on past invoices is made. So these are all different things that a court can look at to determine whether a particular transfer was ordinary. Now, it's important to keep in mind that these are not formulaic. You can't simply add up the number of factors that you can comply with and say, well, we've got 4 in favor and 3 against, therefore it must be ordinary. And that's really pointed out in the Quebcor, the R.A. Brooks trucking case arising out of the Quebcor bankruptcy. The most important thing that courts emphasize and look to in the subjective test really is the timing of payments. So, you know, late payments or even early payments, anything not in compliance with invoice creates the presumption that it is not ordinary course. Now that presumption can obviously be rebutted, and that's largely what defendants do in these cases, is attempt to rebut the presumption that late payments, or in some cases early payments, are actually ordinary course. So what you do is you compare the relationship during the 90 days prior to the petition date to the time period before the preference period. So the greater deviation in payment time from this historical period, the less likely the defendant will be able to satisfy the subjective problem. Step 1 in doing this comparison is to establish a baseline of dealing. This should really, the baseline of dealing needs to refer to a time frame when the debtor was financially healthy. We'll talk in a minute about sort of when that might be. And the greater the payments during the preference period deviate from this baseline of dealing, the less likely a defendant will be able to show or satisfy the subjective problem. So what period should you choose? And the answer is, it really just depends on what period is going to be most advantageous to you. And there are a number of different considerations. I mean, you can choose the 12-month period, 20-month, 24-month period. There might be some period longer. But the key factor is that what you're really trying to sort of pull out of this data is, when was the debtor most financially healthy? When was the relationship at its most normal? And so you might have a 5-year history and perhaps that, over the course of that 5 years, only 2 years is an accurate picture of when the debtor was financially healthy. One strategy is to remove the 90 days or the 180 days prior to the preference period, the 90-day period, 90-day preference period, or the full year preference period. Extract 90 or 180 days from that to get even further back to present a picture in a way that's more advantageous. But the central theme here is that you're trying to present a picture of when the debtor was most financially healthy. Okay, so you've got your baseline. One other point to make here is that you can't change the credit terms right before the bankruptcy filing and to artificially create a new historical baseline. And that really came to light in this Hechinger case out of the Third Circuit. The defendant creditor in that case argued that the ordinary course of business defense applied because all the allegedly preferential payments were within credit terms and were otherwise timely, and therefore presumptively ordinary course. But the bankruptcy court disagreed, and on appeal, the Third Circuit affirmed. And so I think the facts sort of are interesting here and drive this point home. So about 4 months before a bankruptcy filing, the defendant creditor and the debtor had a meeting to discuss the debtor's financial situation and possible solutions in order to allow the companies to maintain their business relationships during the upcoming spring season when the debtor's needs were at their greatest. So they weren't really discussing financial problems. What they were really talking about is the debtor had significant needs during the spring season. So prior to this meeting, the debtor had an open line of credit on terms of 1%, 10 days, net 30, and a 7-day mail float. So under this arrangement, Hechinger, the debtor, could earn a 1% price reduction for invoices paid within the discounted period, and then 10 days, namely 10 days, plus a 7-day grace period for payments made by mail. And then the debtor had up to 30 days to pay in order for the payment to be considered prompt. The debtor paid by check, accompanied by remittance advices that matched each payment to particular previous invoices. Now at the meeting, which again was 4 months before the bankruptcy filing, the parties changed the credit terms to $1 million credit limit versus unlimited for future purposes, and its credit terms were reduced to 1% 7 days, net 8. Which simply meant that the debtor could earn a 1% price reduction for invoices paid within the 7-day or discount period. And then they had up to 8 days to pay in order for the payment to be considered prompt, which was a departure from the earlier relationship, was a full 30 days. And then they also switched from check payments to wire payments. So this was a good departure from the history before that. Now, after filing for bankruptcy, the creditor was sued on a preference, and they raised the ordinary course of business defense. And as I mentioned earlier, they argued that because they were always on time and in accordance with the written terms of the parties, it was considered presumptively ordinary course of business. The courts disagreed, and the Third Circuit upheld the bankruptcy court's determination that it did not apply because, quote, the changes the defendant creditor had imposed on the debtor were, quote, so extreme and so out of character with the long historical relationship between these parties. So, it's important to note here that, your ordinary discussions or negotiations with the creditor could ultimately be determined in the context of an ordinary course of business challenge. And even though you think there was no, this was the new norm, these are the new terms, a court's going to view that slightly differently, and it's going to look to a much larger period, or you at least are at risk for that. So that's something to keep in mind. Okay, so we talked about step 1, which is to establish your baseline. Now let's talk about step 2, which is to compare the transfers during the preference period for the payments during the historical period, or the baseline period, whatever you call it. And here's where it gets quite interesting, because there's really no limitation on what you can do as far as making your case. I mean, there's an endless potential for comparison, and there's really no set standard. A review of the cases, and I'm sure I haven't reached the end of the road on this, but I've seen mention of a range of lateness method, an average lateness method, weighted average method, standard deviation method, and I'm certain there are other statistical models that you can use. But based upon most of the cases I've been seeing lately, it seems to be the trend is in favor of an increasingly complex statistical analysis. I'm certain that parties themselves, whether they be creditors or trustees or debtors, the parties themselves are getting more sophisticated in what they are offering as demonstrative exhibits in litigation on this topic. And even in settlement discussions, you're seeing much more complex statistical models sort of showing why a particular set of transfers is or is not within this ordinary course of business exception. And it seems that judges have become a bit more receptive lately to, increasingly complex statistical analysis. So let's just talk about a couple of these and how you might put them together. So the first one is I think the most simple of all of them to understand, and it's simply the range of lateness method. And so you take the historical period data, take the lowest and the highest number of days from the invoice period to create a range. And basically any payment during the preference period that falls within this range is considered ordinary. And so this is a very simplistic approach to the concept of ordinary course of business, and one that actually courts continue to accept today. I mean, there's this Foreman v. Moran Towing Corp. Arising out of the AES Thames bankruptcy case in Delaware, Judge Carey. So in Foreman, the trustee argued that the court should look at the average lateness test and pointed to the fact that during the historical period, the debtor paid the creditor an average of about 2 days after the due date, while during the preference period, the debtor paid the creditor an average of 15 days late. In addition, during the historical period, only 4 of the 164 invoices, or about 2%, were paid 10 days or later after the due date. Therefore, the trustee concluded that preference payments did not conform to 97% of the historical payments. On the other hand, the creditor argued that during the historical period, the payments ranged from 28 days before the due date and 35 days after the due date, so like a 60-day range of actual payments. Therefore, the range at issue in the case, 10 to 18 days, was perfectly within the historical range. Judge Carey rejected the trustee's argument for the adoption of the average payment statistics because he did not believe that they portrayed a complete picture of the parties' relationship. And his basis was that it was, quote, not unprecedented in the parties' relationship, which to me is, almost anything could be not unprecedented in a parties' relationship. So when he coupled it with some of the other factors that we talked about before, such as consistent payment method, no unusual collection activities, and he also considered the length of the parties' relationship, he concluded that it was the type of relationship that was intended to be protected by the ordinary course of business defense. So a pretty interesting decision, and a very recent one, utilizing this very simplistic approach to what is considered within the ordinary course of business. Now, in contrast, you have the average lateness method, which is compares the degrees of lateness of each of the alleged preferences with a pattern of payments before the preference period to see if the alleged preference fall within the pattern. This uses age buckets and some other models. It's basically an averaging, and you saw an example of this arising in the Quebecor bankruptcy case, the R.A. Brooks Trucking adversary proceeding. Judge Lane, by the way. So in the R.A. Brooks Trucking case, the defendant asserted the total range approach, which was the same one that Judge Carey accepted in the last case we discussed. Judge Lane rejected it as, quote, impermissibly expanding the ranges of ordinary transactions. It captures outline payments that skew the analysis for what is ordinary. In contrast, the plaintiff trustee asserted the, quote, average lateness method. Here's what the trustee presented to Judge Lane, and you'll see it's fairly compelling when you add color and buckets and things like that. Judge Lane found the chart persuasive in demonstrating that a significant disparity between the average payment times during the historical period versus the preference period. And you can see, so the average days to pay during the historical period was about 27.5 days versus 57 days during the preference period, or a difference of about 30 days. The bucketing analysis revealed that about 88% of the amount paid during the historical period was paid between 11 and 40 days, whereas only 22% during the preference period were paid during the same date range. So he held ultimately that payments up to 45 days should be considered ordinary. It's not totally clear how he came up with that actual number, but just this chart sort of shows you, in the red versus the blue, the red being the historical period, the blue being the preference period, how a visual representation of the dramatic difference between the two presented a very compelling case for Judge Lane. So another method used by judges is this weighted average method. And this is calculated by multiplying the amount of the invoice by days it took to get paid and then dividing the value by the total amount of the invoice's data set. And this takes into account the relative invoice amount and generates an average based on the days to payment. And it's a bit more comprehensive than a simple straight average method. It doesn't put as much weight on small invoices, puts more weight on larger invoices. And what you'll see is that this weighted average method is often combined with the average lateness method used by Judge Lane in the prior case. So here's the last one I'll talk about. That's the standard deviation test. And this is relatively new, and I haven't seen it used a lot. But here again, you have Judge Lane in a case applying it, or at least being receptive to it. So standard deviation is a statistical measure of the amount at which a set of values differ from the arithmetical mean. In plain English, when the standard deviation number is applied to both sides of the mean, the numbers that fall within the resulting range will encompass 67.76% of all numbers used to arrive at the mean. So it's similar to the average lateness method, and it serves to view the payments centered around the mean. So in this Pereira versus UPS case, again another Southern District of New York, Judge Lane, the defendant UPS, offered the testimony of an expert, one of its employees, and argued in favor of the quote range of method test in context of the objective or industry test, which is a little bit different than what we're talking about now, but they applied it, and it could be relevant here. Again, Judge Lane rejected the range test as being too broad and unreasonably extending the range. The trustee, on the other hand, argues for the adoption of a single standard deviation from the mean, citing an article published in the ABI journal proposing certain statistical models for analyzing preference claims. Judge Lane accepted it, arguing that it's more accurately reflected what was ordinary in the industry. Now, it's tough to know exactly why Judge Lane is receptive to these more complex statistical models, whereas it seems that certain judges in Delaware are much more receptive to the very simple sort of range tests. I mean, for example, Judge Sanchi, also another Delaware judge, in the Stanzial versus Industrial Specialists case arising out of Connex bankruptcy, and this is from 2014, he flatly rejects statistical models not already used by the court. And in that case, it was the dollar-weighted days analysis, which I'm not completely familiar with. But so they clearly reject some statistical models, whereas Judge Lane in the Southern District of New York is very receptive and open to these new mathematical models. So, you know, I don't have a great explanation as to why some judges accept it while others don't. All I can say is, you know, perhaps start with a simple model and then add as many layers of complexity as are advantageous to your particular case. And at that point, you'll probably have made all judges happy. But again, it's just tough to say. So what we talked about before was the subjective test and the various models that that defendants and plaintiffs will use to prove their particular case. The third piece of this is under 547C2B, which is the objective test. This one is, again, this is an alternative test to the subjective test, and it's a comparison of the parties' payment terms to payment terms in both the creditors and the debtors' industries, as well as general business standards. And what you have to show to satisfy this standard, and it's a bit looser than the subjective standard, but you have to show that the business terms of the transaction in question were within the, quote, outer limits of normal industry practice, and only dealing so idiosyncratic as to fall outside the broad range should be deemed extraordinary and therefore outside the scope. And one thing that courts are starting to do in the objective test is to look to the mathematical standards in the subjective test as a proxy for what is ordinary within the industry. And so this adds another layer of complexity to what is otherwise supposed to be a relatively straightforward test. So to satisfy the industry test, step one is to define the industry. And courts will differ on the relevant industry. I mean, is it the debtor's industry? Is it the creditor's industry? Is it both? Are there other general business standards that are common to all businesses that also must be considered? It's really a question of how broadly or narrowly the relevant industry must be defined. And the Seventh Circuit in the Tolona Pizza Products case had an interesting comment about the problem of defining the industry in that case. And what they said was, this is a quote about the industry. Not only is it difficult to identify the industry whose norms shall govern, is it here the sale of sausage to makers of pizza? The sale of sausages to anyone? The sale of anything to makers of pizza? But there can be a great variance in billing practices within an industry. So that just gives you an example of all the different ways you can slice and dice a particular industry to figure out what is the industry. Okay, so once you define the industry, step 2 is to prove that the transfer was consistent with industry standards. Here, the evidentiary standards, similar to the subjective test, are quite flexible, and partially because it's difficult to retain information about competitors' trade practices in many instances. Some industries lend itself better than others, but nonetheless, it's a flexible standard. So one thing you can offer is, expert testimony. These can be actually hired experts on a particular field. They can be corporate representatives and long-term employees, and they can testify about the industry credit payment, general business terms. The only thing you have to do is satisfy the federal rules of evidence. The other thing you can offer, or that your experts can rely upon, are available industry data. Depending on the industry, it may be possible for experts to utilize published data. And for example, I've seen a few cases where this has been done with some success. For example, in the AFA bankruptcy case, there was a preference action where they used a service called BizMinder, which is a leading producer of industrial statistical reports. It's an industry-wide report showing the average days that receivables were outstanding. Another resource was the Risk Management Association, which is a publisher of an annual statement studies in which financial ratio benchmarks are reported by industry. These are very recent cases as well. This is a 2016 case. And then the final example is this Credit Risk Monitor database, which monitors the average number of days for a company to receive revenue after a sale has been made. That comes again from this Pereira v. UPS case in the 7th District of New York before Judge Lane. So those are the standards under the ordinary course of business test. With that, I'm going to turn it over to David to tackle the subsequent new value test.
Thanks, Robin. With the time remaining, I think I'm going to try and move through some of this relatively quickly, because we wanted to spend a fair amount of time on ordinary course, because that's where you're seeing a lot of the case law these days, and that's the litigable defense. New value, as many of you know, if you've ever gotten a preference demand, sometimes the debtor or the trustee will have had turned over to them from the company all of the historical data that the company has, such as it is, and sometimes you'll get a preference demand that is allegedly net of new value, and so part of your task and challenge is to figure out whether you agree with that new value analysis. But as I said before, new value is a bit of a more perhaps formulaic approach to looking at that one particular area of the defense, although there are some nuances to it. And so obviously, as we say here on the slide, it's intended to encourage creditors to work with troubled companies. New value is given after the preferential transfer is made, and the preference is repaid to the bankruptcy estate. So theoretically, the estate assets are not disadvantaged or depleted. So just we put what you have to show at the bottom of this slide. That's to give new value to the debtor after the transfer. It's not secured by an otherwise unavoidable security interest, and on account of which new value the debtor didn't make an otherwise unavoidable transfer to or for the benefit of the creditor. Let's see if I can move the slide. If I so the timing of the transfer. A transfer involving a payment by check is deemed to occur when the check is received by the creditor. The transfer must not precede the provision of new value, obviously, because it's a subsequent new value. And Section 547C4 rejects the net result rule. In the old days, people used to just, total up In one column, the preference payments received in the 90 days, and in the other column, the new value, and they used to do just a net result, and that's not permitted. We have some slides here on the timing of a new value. Unlike payments, new value is generally counted on the day the services are provided or the goods are shipped to the debtor. It's the date of delivery, not like you may have remembered from other things you heard. It's not the clearance of the alleged preference. You don't want to confuse those two with the Supreme Court decision in Barnhill that talks about clearance date for checks for what constitutes a preferential payment. So you have to generally prove new value was given after the preferential transfer, new value was unsecured, and the new value remains unpaid. Put a star in that one because there's a split of authority on whether it has to be unpaid. The language on account of which a new value debtor did not make an unavoidable transfer to or for the benefit of such creditor has led to these two different interpretations about whether it has to be unpaid new value or the subsequent advances approach. In order to use the new value defense under the unpaid approach, the value must remain unpaid at the end of the preference period. Again, the policy behind that was the notion that the statute wants to promote equality among creditors, and the notion that the estate is being enhanced and replenished by the new value. The subsequent advances approach is if a debtor makes a payment on new value, the new value may be used to avoid a prior transfer to the extent that payment on new value is not an unavoidable transfer. And that's sort of the trend. There's been a split in the case law on this, but in the various circuits that have presided over the issue about whether new value has to remain unpaid. But Judge Sanchi fairly recently in the Delaware Pro-Alliance decision that he rendered said the more modern view suggests that the subsequent advance approach is the favored approach. Some of you are probably familiar with pillow tax that preceded Judge Sanchi's pronouncement we put here, and that all keyed off of pillow tax, keyed off of whether courts really held and whether the Third Circuit really held that new value had to remain unpaid. And Judge Carey in the pillow tax decision was, I think, the first one in Delaware to say that there really isn't any controlling law, that all of the prior decisions on this issue, including in the Third Circuit, were really in dicta, and therefore the lower courts, the bankruptcy courts, didn't have to follow the language or reach the conclusion that new value had to remain unpaid. And so on the next slide, we just give an example of the subsequent advances as was analyzed in the Pro-Alliance decision from Judge Sanchi. And you can see in the slide, whether you use the remains unpaid approach or the subsequent advance approach, you can have about a $4,000 swing in the remaining preference exposure, and that's a significant swing, and why the subsequent advance approach, which appears to be the modern approach, is more favorable from the perspective of the defendant. The next thing I want to touch on, because it comes up and it probably comes up in your lives, is the new value and the interplay with 503B9. 503B9, as many of you know, is the section of the code that provides an administrative claim for the value of goods received by the debtor within the 20 days. And the question became whether the new value defense is limited to situations where the creditor gave new value on account of which new value the debtor didn't make an otherwise avoidable transfer. So is the 503B9 claim an otherwise unavoidable transfer? And here again, there's been a split of authority, and the reference being to double dipping, and I'm sure you're all familiar with Circuit City. Some courts have determined that the bankruptcy policy is furthered by restricting the use of the value of the goods shipped either as new value or as an administrative claim under 503B9, but not both. So you can't have it both ways. You can't have both your 503B9 claim and use it as a defense to preference. And that was Circuit City and another case called T1 Acquisition. But at least some courts have held that double dipping, as we're referring to it, and as some of the other articles out there refer to it, is permitted reasoning that to do otherwise would force creditors to choose between exercising their rights under 503b9 or preserving their new value defense. And that again comes back to the consistent intent of 503b9 and 547c4, which is to encourage you all to continue to sell on credit and do business with debtors. And that's the commissary operations case in the Middle District of Tennessee from 2010. There's also some case law out there conflicting on whether just a straight reclamation claim can be used as a valid defense to a preference. And again, there are conflicting decisions. Decision out of the Middle District of Tennessee and one which allowed inclusion of reclamation claims as part of the new value defense, and another from Arizona which said you couldn't use a reclamation claim as a defense to a preference as a new value. In that case, though, it was primarily because the creditor was paid post-petition on account of their reclamation claim. And we touch on that here in the next slide. In particular, some of the other things that come up are critical vendor payments and wage payments, and whether critical vendor payments can be used as a new value defense. Courts are divided on that. And in the Friedman's case, there was even a question of whether a payment under a wage order could be used as part of the new value defense. So with the limited amount of time we have left, let's just touch on some of the takeaways. First, we always tell our clients, take the money. There's a 2-year statute of limitations for pursuit of preferences. So we advise our clients, don't think too much about whether you're taking a preference payment or not. You should take the money because you have the use of the money, and you might have the use of the money for up to 2 years before someone comes knocking on your door. Obviously, if you can establish a baseline of dealing and then keep it consistent on a regular basis, that's going to help you with your ordinary course defense, among other things. Establish early lines of communication. The preference demand letter shouldn't be ignored. If you get a preference demand letter, you should open up a line of communication. Cash in advance, obviously if you require cash in advance or COD, those insulate you from preference exposure. Obviously, if you obtain collateral, then you're not you're a secured creditor, whether you get a deposit or a letter of credit. Even although it's not a form of collateral, a third-party guarantee may even help you in preference land because it can help you put pressure on perhaps a principal of the company or something as part of the overall settlement. Don't ignore demand letters because that might just provoke a filing of a complaint and give you less time. Make sure you have time to review the facts. We can't stress that more critically. Like I said, sometimes you get a demand letter that's already net of new value, and you need to look at that and make sure you agree with the new value analysis the debtor or the trustee or the liquidating trust has done, because we've found in our experience they don't always do it the way you would. Make sure you know the facts in terms of, we give you some of the points here. And then I think the last couple of points to make sure the plaintiff knows the facts. They may be relying on the debtor's books and records, and debtor's books and records are notoriously for crap. And so they might not have the best information. And then as part of a holistic approach, you want to estimate your costs of defense. Obviously, you want to figure out what you think your exposure is, and then think about what it's going to cost you to defend. A lot of preference litigation, unfortunately, consists of the trustee or the debtor or the liquidating trust literally holding you upside down and waiting to see what nickels will fall out. But it's important to know that in some cases where the trustee's trying to generate a recovery for creditors, especially if the case was administratively insolvent, they're going to need to get something, even if it's a de minimis amount, out of settlement. And then the last thing is, obviously, settlement is achievable in almost every case. As Robin said at the beginning, almost no case goes to trial, despite the fact that we have a fair number of reported decisions in this deck. The vast majority of these cases don't go to trial or court. They settle, and most trustees are offered to settle out of the box for anywhere between 70 and 90%, even if there's no defense. Be aware, in some jurisdictions like Delaware, there's mandatory mediation, so you need to factor that into your thinking about preferences and how much you're going to spend on the preference defense. And then the last thing I would note, and it's what I always tell my clients, is if you have strong defenses and you think your exposure is not great, if you settle anywhere from 0 to 25 cents on the dollar, obviously as low on the range as possible, you probably hit a home run if you haven't expended a lot of time in legal expense dealing with it. And from the trustee's perspective, it's exactly the opposite. If or the person pursuing preferences, obviously people who pursue preferences often do it on a contingency fee basis. So if they settle with minimal effort after a demand letter or a complaint is filed for 75 cents on the dollar or above, they hit a home run. So that the play is really in that range between 25 and 75% on the settlement, in terms of where the rubber's going to hit the road in terms of defenses and what the view is of how good a settlement is. So that's it. Any questions? We went a minute or two over, but we tried to cover everything.
All right, thank you very much, David and Robin. We do have a couple of questions in here. I do want to let anyone know, if you do have any questions, feel free to type them into your questions panel on the side pop-up screen, and we'll be sure to get to them. And if we don't get to them, I'll be sure to pass them along to both David and Robin, and they can reach out to you individually. I do also want to remind everyone that we do have a brief survey that will pop up as you exit the webinar. Again, it only takes about 30 seconds to fill out, but it gives us a lot of great information on how we can continue to make these webinars better for you. The first question we have here is, someone has heard that switching a customer's term to prepayments before the goods are shipped protects them from preferences. Would this be the case or not, based on the ordinary based on history comment that you made earlier?
Robin?
What was the first word? I'm sorry, you said if they switched it to what?
Prepayment.
Prepayment. I mean, yeah, so it has to be on account of an antecedent debt. So to the extent you are prepaying an obligation, there's not going to be any antecedent debt. And so you would defeat one of the necessary elements of a preference claim. So that's certainly a strategy that you see some creditors taking to try and sort of get out of the preference business at all. That often doesn't comport with the relationship the creditor is going to want to have with the debtor, and the real art and science of it is knowing sort of where the middle point is. I mean, at what point is it okay to ask for, whether it's payment in advance or cash on delivery, whatever, without harming a relationship that you value? And that's really a business decision. But to answer the ultimate question, I mean, if you can defeat an element of the action itself, such as payment on account of an antecedent debt, then certainly that's a strategy that you could pursue.
Yeah, and obviously it also depends on timing of when you switch. Obviously, if you're halfway through the preference period, recognizing it's hard to know when someone's going to file for bankruptcy, but you all are sophisticated people and you continually monitor your credit situation and what you're seeing in the marketplace. But if you switch, halfway through the preference period to prepayment, you might not be able to defeat the entire preference exposure based on an ordinary course.
Yeah, and one other thing to consider here is that trustees are motivated, as David mentioned before, to get the most bang for the least buck. So if you've muddied the picture as far as what is recoverable, you've made it a more difficult case for them to pursue, it's another feather in your cap. Now, if there's big dollars involved, a muddy case won't necessarily dissuade them from pursuing you, but when you sort of fall in that lower spectrum of less relevant to the debtor and higher cost to recover, then it could be a worthwhile strategy, even if there's some risk left over, as David mentioned.
All right, the next question we have here is someone's received a preference demand for less than the $5,475 minimum floor for a commercial Chapter 7. Has the minimum floor changed, or are they within their rights to argue this demand is less than that amount?
I don't think it's changed. If anything, it's it's going up. So yeah, that would be a defense to pursue, and I'm not sure why the trustee would send a preference demand for an amount less than the statutory threshold.
Yeah, I think the threshold has gone up, and it certainly has gone up for purposes of compelling the trustee to have to sue the creditor in its home forum rather than in the forum where the bankruptcy is. But the other thing to remember is what I said, which is part of the game. Game. I hate to use that word. Is lots of times they send out demand letters even though they know they can't sue because they're waiting to see if they can hold you upside down and see what nickels are going to drop out. Or said another way, they can make a demand even if they can't necessarily sue on the demand. And you see trustees do that, where they'll send out demand letters to everybody, even though they know that they might not be able to actually commence suit.
Okay, great. The next question that we have here is, when a debtor in possession is listed on a business credit report, who exactly is in control of releasing payment, and what risks are associated with doing business with a new customer in this situation?
So,
a little bit of, a little bit of field of, I think the preference question, but I'll try preference issues, but I'll try and answer it this way. I mean, there theoretically under the bankruptcy code is a difference between the debtor and the debtor in possession. The debtor in possession being the entity that theoretically exists upon the commencement of a petition. So if someone's listed as a debtor in possession, then that to me means they're already in bankruptcy. So preference is backwards looking. It looks at the 90 days prior to the bankruptcy and antecedent debt. Obviously, if someone's already in bankruptcy, two things. One is if you don't already have an existing relationship with them, you can demand whatever terms you want, including cash on delivery or cash in advance, especially if you're concerned that they're going to have administrative solvency issues in paying you. The other thing is if you want to do business with someone who's a debtor in possession, theoretically, if you do business with them and they don't pay you, you're entitled to an administrative claim for the cost of the goods or the services provided, because that's what it means to do business with a debtor in possession. Of course, again, you're taking a risk. They're not going to be administratively solvent, and they're going to be able to pay you in the ordinary course. But theoretically, that's what they're required to do. Hopefully that answered I think that answered the question.
All right. All right. It looks like that's all the questions that we have in here, and I know we're a little bit over time, so I think with that we can wrap the webinar. I'd like to thank everyone for taking the time out of their day to join us, and specifically thank David and Robin for putting on a great presentation for our membership base. With that, I think we're going to close the webinar, and I hope everyone has a great rest of their day.
Thanks, everyone.
Thank you.